Where is your criminal revision petition 12?
Criminal revision petition is
Okay, I have found it, yes. Now, after this order of the High Court passed on 17/7/2023, at page 33,
yes.
then what happened thereafter, before the trial court? You
After
had
that-
submitted this order to the trial court on 19/7, isn't it?
Yes.
At page 36.
Yes.
Then what happened?
Lordship, I have bought the production. There only there's in production. No,
You
any,
speak in the mic.
the stage is now in the production. After that, nothing has been done. For
Just-
as per the provision.
Just a moment. When this matter was, as per the order you have annexed, the trial court had taken up the matter on 10 July, is not it?
Yes.
10 July 2020, at page 26.
Yes. Yes.
That was the date fixed for determination of the age of the victim
Yes. And final argument.
and final argument.
Yes.
Neither you were present. You means the counsel for the, is not it? Accused was present, nor the PP was present. So the court passed an order fixing 17/7/2023 for production of the accused person from the again. Then on the same day, you were here in High Court. When the case was fixed on 17/7, there at the trial court, you were here in this court arguing IA 41. And on that date, 17/7/2023, this court passed an order
Yes.
to determine the age within 1 month.
Yes. Yes.
You submitted this order on 19/7/2023 before the trial court.
Yes.
What happened after 19/7/2023 before the trial court?
No one, Lordship, my submission is the
You submit later on, just tell this court what happened after 19. Yes, what
Yes, but-
happened after 19?
my lord, here is a after the this honorable court order and dated 17 July 2023. And when this court is directed the determination age of victim. And then there is no require for the advocate has to be present, whether advocate should present in the court or not. So
Okay.
therefore,
Okay, that is up to you, but what is the proceeding of the trial court after 19 July?
after 19
It can't be the case that after 19 July, this case was not taken up. It was taken up.
after 19 July, yes. Therefore, the only for the production. Yes, but I have the yes, in the reflected and the post, this is the production one.
Just don't show the cause list. Of which date?
This is the date
We
of
are not going to look at any papers which are not here.
23 August 2023.
23 August,
Yeah, 23.
what happened on that
The
day?
stage of the production. There is no hearing, no any inquiry, just the production of the accused person.
Where is your application for determination of the age?
My
You have
application,
to pursue. You have to contest the case, Mr. Lamnia. That
Lordship,
the
my
victim, that
application-
the victim
my
is a major.
my application, Lordship, on the petition number 214.
Have Mr. T. Lamnia, learned counsel for the petitioner. This contempt case. This is an application under section 215 of the Constitution of India, read with sections 11 and 12 of the Contempt of Courts Act 1971, read with Rule 9 of. This contempt petition would lie against the court, judicial officer.
Yes, sir.
Yes.
Yes, sir. Sir. Yes, sir. But section 10 of this Contempt Act. The
Okay,
High
all
Court
right.
is the jurisdiction, yes.
Read with section 11 and 12 of the Contempt of Courts Act 1971, read with Rule 9 of the Contempt of Courts, Guwahati High Court Rules 1977. Alleging willful and deliberate disobedience of the order dated 17/7/2023, passed by this court in criminal revision petition 15/2023, whereby the POCSO court, Bomdila, was directed to comply with the order dated 16/6/2023, passed by this court in criminal revision petition number 12/2023, and determine the age of the victim as per law before final hearing of the argument within 1 month. Full stop. It is the case of the petitioner that order dated 17/7/2023, passed in criminal revision petition 15/2023, was submitted in the court of special, submitted to the special judge POCSO, district and sessions judge West Cumming, East Cumming and Tawang at Bondila on 19/7/2023. Full stop. Despite the order dated 17/7/2023 having been submitted by the petitioner to the special judge POCSO, district and sessions judge Bomdila on 19/7/2023, the special judge POCSO, district and sessions judge, has not determined the age of the victim as directed by the order dated 17/7/2023, passed in criminal revision petition 15/2023 also. Though the contention as above has been raised, no material has been placed on record showing the status of the proceeding of the. You have to approach there. There is no reason why the court will not determine the age.
No, sure,
Yes,
the special court has not going through the provision.
you have to lead the court. Don't,
Yes.
you will not gain anything by fighting with the court.
No, I'm
You,
not.
you have to lead the court.
Not sure, I'm going for the provision, as well the provision, not, it is
All
not
right.
fighting with the court. Number 32. All right.
Yes,
Well, the work order and the power of attorney was asked for, and we have filed in the form of affidavit. My lord.
what is the matter about?
The case is, my lord, the respondent number 2 is the illegitimate son of the petitioner. 1991, there was a Keba decision. The issue was resolved. Again, in 1989, final resolution was done. And in 2015, he again tried to open up the case without challenging those cases. Then thereafter, my lord, still the respondent number 2 is insisting that the father should part it with the property. Law is there, my lord. Even illegitimate child also has a right of getting property. But the manner the private respondent has adopted is uncalled for, my lord. For the reasons that there was a contract work awarded to me, and I have executed
Where is your affidavit?
when asked to call for. Now on 26, he submit 26/6/2023, he submits a representation to the deputy commissioner. And deputy commissioner passes the impugned order on 10/8/2023. And again on 21/8/2023, directing the village authority to expedite the matter, which he do not have the jurisdiction after the Civil Code Act. Secondly, he does not have the power to direct the executive engineer to captain avails the work, and for which I have lost the representation before the deputy commissioner. But this impugned order has to go, madam. He do not have the power. Well, I will come to the impugn order at page 33 and 35. There at 10/8, 2023. Yes, ma'am. 28, page 28. Para 3 is the fact of the case. Page 29.
Yes, what do you say? Government?
Lordship, for this impugn order was passed because there was a complaint by the private respondent that their
Mhm.
construction is going over the disputed land between the petitioner and the private respondent. So the ADC wanted the land to be settled first, Your Lordship.
Hmm?
The disputed land to be settled first, Your Lordship. That is why this order has been passed, Your Lordship. And there's an order of the High Court also to approach the appropriate forum, and the private respondent has submitted representation before the government also, Your Lordship. He has already submitted the petition.
Okay.
Is
You serve notice to respondent number 3 by Dusty, then we'll pass order. Will you notice?
this has to stay, my lord. He do not have the jurisdiction.
We will not stay at this stage because we'll hear the respondent number 3.
No,
Within 2 weeks, we'll hear it. Nothing will happen within 2 weeks. You.
no, my lord will kindly
serve the
see,
Dusty.
my lord kindly appreciate on two counselor. Kindly give me 2 minutes in that. Number one, whether the deputy commissioner has a power to direct the village authority, which is the,
That is why we are issuing notice. See, there appears to be a land.
one minute. And number two,
There appears to be a land.
he is my illegitimate son. He is claiming property from me. I am the father who will determine whether to give him or not. And if my lord will come to that,
He is nevertheless your son. Let us hear him.
that is the relationship between a good and a bad father, my lord.
Yes.
But a good son cannot afford to cause hardship to the father.
Let him be a good, so you be also a good father.
I'm a good father. my lord.
Legitimate or
That's why
illegitimate?
89, I have settled the score with him. 81 and 89.
Had Mr.
Well, kindly suspend this. He do not have the power to direct this.
If you say so, I will also have to point out certain deficiency in your power of attorney, and then your work order. I don't want to discuss at this stage. Let him appear, we'll discuss it.
Is that a score below them?
No, Mr. Within 2 weeks, what will happen?
1 week.
You have seen your power of attorney, work order? I don't want to say anything today. If you insist for a interim order, I may have to then open up this chapter. 2 weeks?
Give them 1 week. We'll take Dusty as well.
Okay, 1 week also.
Why this?
Heard Mr. Titi, the learned counsel for the petition, and Ms. R. Vassal, learned government advocate representing respondent 1 and 2. Issue notice returnable in 2 weeks. This type of service should notice upon respondent 3 be taken by registered posted as usual process within 3 days. Dusty in addition is also permitted. Listed after 2 weeks.
But I am in this writ petition. I am challenging the impugned clarification letter dated 28/8/2023 at page 36. Well, here, before I indulge my lordship with the annexures and all, a NIT was plotted by the executive engineer, Pasigat, PhD. For 4 small packages, my lord. Then in the terms and conditions, my lord, what they say is that you need only other than 2 documents, my lord, that insurance and 1 more documents that has to be attached, and rest in clause 11 of the NIT, my lord. What they say is you produce at the time of evaluation of the bid, my lord. Before this, my lord, kindly come to the NIT for a moment.
Page number?
Page number 23, my lord. We are concerned with the package 1, 2, and 3, my lord. That is 27 July 2023. my lord.
You are concerned with package number?
1, 2, and 3. Yeah?
1, 2, and 3. Yes.
Then, my lord, kindly come to the page 24, next page.
24.
Yes. No, 24. That is clause 2, my lord, will see.
Hmm.
The standard form of general conditions of contract will not be issued along with the tender documents, but the same shall form part of the agreement to be drawn and signed by both the parties after acceptance of tender. The intending bidder must read the general conditions of contract 2014 or its latest edition carefully. That's the one. My lord will come to special terms and conditions. Now, my lord will pose a question. Have you challenged the tender terms and conditions? I'm not challenging because they are violating it. Page 25.
25. Yes.
Kindly come to serial number 5.
Yes.
The firm must enclose original copy of bank solvency or financial soundness certificate in support of his financial background to complete the project, even on the eventuality of unavoidable delay in payment, owing to such reasons as financial crunch of the client department, stroke government. No interest will, however, be paid for delay in payment.
Yes.
First thing, the my lord has only noted 2 things. Solvency or financial certificate has to be submitted in original.
Hmm.
Now kindly come to serial number 11.
Yes.
The firm should submit the following documents in original at the time of opening tender, my lord.
Hmm.
Except for, my lord, this 2 documents, I have xeroxed it, certified it, attested it, and submitted.
Except for two document means, which document?
That is the bank guarantee, bank solvency or financial.
Solvency, huh? Bank
Yes.
solvency and
Only,
finance.
only financial soundness, only two
Okay.
certificate.
uh,
At the time of filling up the tender, you have to submit. Rest you will have to produce at the time of opening tender in physical form.
Firm should submit the following document in original at the time of opening of a tender.
Right.
Okay.
My lord, we'll
The
see
form-
that that particular clause has to be read conjointly with serial number 19. My lord. Kindly come to serial number 19.
19.
Yes. During the process of tender, any issue dispute shall be resolved on the same day till completion of such process, and thereafter no issue dispute shall be valid. On that particular day, we have raised it. Prima facie, my lord, will see. Now, my lord, come to page 35.
Yes.
Now, my lord, kindly see. Date is 28 August 2023.
Yes.
And this should have been done prior to the issuance of, my lord, these result, my lord, NIT result at page 36. The result was issued on 19 August 2023. Before resolving the issue, this NIT ought to, result ought to have been issued. But in this case, my lord, the laxity of the officer. Now, my lord, kindly come back to page 35 for a minute.
Where is the impugn order?
Impugn order is 35.
35.
Yes, my lord.
35 is the impugn order.
Yes.
What does it say?
They
What
were
does-
supposed to clarify before issuance of the result. My lord. The only on two counts which I have referred to, my lord, that serial number 5, serial number 11, and 19 of the
30
NIT.
35 is the letter you challenge.
Yes. Because you have illegally rejected my bid documents.
28 August.
Yes, page 35. my lord.
Okay.
My lord, receive. So and so, subject clarifications, dated 28 August 2023, Pasigat. Well, I'll read from the second paragraph. In this regard, this is to clarify that serial number 11 of special terms and conditions states that the form should submit the following documents in original at the time of opening tender, where the indicated documents are namely GST registration certificate, PAN card, PRC, ST, 5, farm registration, staff details, technical, TNP availability, proof as entitlement of class of contractors, IT returns. Your tender for the mentioned NIT was not rejected on the basis of non-fulfillment of this very conditions. Now they admit that on this condition, they have not rejected my bid. This is also to clarify that whenever an affidavit is required to be submitted, it needs to be submitted mandatorily in original, never in photocopies unless specified otherwise. This is what run contraries to the terms and conditions prescribed at special terms and conditions. My lord, will turn back to page 25. This is where they are contradicting.
Where is the rejection order?
This is the rejection order. my lord.
This is a clarification for rejection.
Yes, clarification for rejection.
So
That next page is also under challenge. my lord. Page
that-
35.
just a moment. Before this, there is no rejection.
No
order.
rejection, no rejection.
Okay. So here they reject also, they clarify also.
Clarify also.
Okay.
both. Now, my lord, kindly see how they stood on a wrong wicket here.
Your bid has been rejected for what, on what ground?
Kindly
For,
come.
for non-submission of
They says ki
affidavit.
affidavit, because
Okay.
for one firm, one affidavit has to be executed.
What is the requirement of submission of affidavit?
It is not there. Nowhere in the special.
What
terms.
else?
Then
Any-
we'll kindly
Any,
see.
any other ground?
The next fourth paragraph. Further, this is to clarify and inform your firm that the tender submitted by your firm was rejected due to non-submission of affidavit of declaration made between the firm and the technical employed by your firm, which should have mandatorily been enclosed in the technical bid. Now, this contradicts. You have asked me to produce original at the time of opening of the tender, and you are rejecting me. This is something, prophesy not a level playing field, my lord. Please note, it is the firm original copies. Please note that it is also clearly specified in the serial number 19 of special terms and conditions that during the process of tender, any issue dispute shall be resolved on the same day till completion of the process, and thereafter no issue dispute shall be valid. Now, my lord, kindly come. This is, he has passed this, NIT result was declared on 19 August, and then he rejects and issues clarifications on 23rd.
Hmm? Yes,
So therefore, this has to be interfered with. Where is the statement that we have made?
yes, no.
Your lordship has already explained the terms and conditions of the NIT, then also my lord, special terms and condition. As my brother, he referred to paragraph 11, my lord. So in that count, my lord, he's right, my lord. These are the documents which are to be produced at the time of opening, my lord. But the question is, my lord, when you submit the bid document, what are the original document you have to annex? That is very important. So as per this clarification,
His bid has been rejected on what ground?
my lord, non-submission of original affidavit. That is
Original
the- Yes. my lord.
affidavit, that is
So,
one. And
It is
anything,
nothing to do with this, my lord, paragraph, terms and condition of special term, paragraph 5 and 11. My lord. Nothing
paragraph,
to- My lord, page 25, I am referring, my lord.
page
yes.
25, yes.
Yes, my lord. Neither this concern with the bank guarantee nor, my lord, paragraph 11, my lord, GST, PRC, ST, PAN card, all these things. But well, it's nothing to do with that rejection. My lord. The rejection is only on that ground, my lord, non-submission of the affidavit is original.
What is the requirement of submission of
My
affidavit?
lord, that, my lord, I have to take instruction. Besides
Okay.
that, your lordship may kindly see that, my lord. My
Which
lord, this
one? Which
NIT, my lord, page 36, my lord.
Hmm.
My lord, why I'm referring is very important because now we are in, my lord, September. This is 27 July 2023. It's more than 1 month.
No, it is 19 August.
No, I'm referring to 36, my lord, this
Ah,
final result.
Okay.
Final result.
NIT result was in
It's already declared, my lord.
27 July.
That's why I
27.
refer to below that
No,
serial number 19, sorry, sir, serial number 19. On the date of declaration of result, only the dispute has to be resolved. But here he put,
Work has been allotted.
Yes, my lord,
No, no.
as per this, my lord, NIT result, my lord, it's long time back, my lord. 27
All right.
July 2023, my lord. That is the
Let,
only problem.
okay, let him receive instruction.
Or my lord, so notice may be issued within 1 week, my lord, will come up with the affidavit, private respondents.
but kindly interfere with, for a week, let them come with, I will not seek further extension, my lord. In tender matter, my lord, will kindly,
Had Mr.
I will not agree to that, my lord.
Since it dates back to July,
Yes.
we should notice 2 weeks.
Yes.
1 week, let him come with,
No,
because,
it's two.
my lord, the
You,
latest judgment.
you have come after 2 months.
No, no,
So
no.
at least wait for 2 weeks.
My lord, kindly appreciate.
Had Mr. Titi Talana counsel for the petitioner and Mr. R.S. Navam Leonard,
1, 2,
additional
3, my
senior
lord.
as government advocate representing respondent 1, 2, and 3. You should notice returnable in 2 weeks. Navam accepted 1, 2, and 3. Steps for service of notice upon respondent 4, 5, and 6 be taken by the supposed AD, it will be used within 3 days. Thus, the addition is also permitted. Listed after 2 weeks.
The entire tender process shall be subject to outcome of writ petition. Thank you.
Okay,
No objection for that.
yes. The, with the. What is the NID?
Case 23.
Okay. Work for the issue pursuant to
One, two, three.
NIT dated 27 July 2023
You lordship only speak of particular package or.
in respect of package number 1, 2, and 3.
Three.
NIT dated 27 July 2023 issued by the executive engineer PHE and WS division by number so and so at page 23 in respect of package number 1, 2, and 3 shall be subject to the outcome of the repetition.
New latest judgment has come.
Hmm.
The Madras Aluminum Construction Private Limited. State action, even in the realm of tender, must be in conformity with Article 40.
Hmm.
There's 3 bench. Because here,
Overwhelming,
why I- no, no.
no.
that Jagdish Mandal paragraph 22,
Hmm.
paragraph 22, if my lord final reads paragraph 28 of the Jagdish Mandal,
Hmm.
then finally that NG products judgment came. And thereof that NG product is by the division bench. The Jagdish Mandal is also division bench, but this Madras Aluminum Construction Agency latest judgment
Hmm.
is by Justice Gabai with the quorum of 3 judges.
Okay.
It says now it is no more res integra. This has been settled. Earlier, the courts were very reluctant because of this NG production, and no interim order should be granted. This has been done away with. Gratefully.
All right.
Wait.
Yes.
Land compensation matter, affidavit has not been filed yet.
Yes, Mr.
Some more time may be granted.
How much? Had Mr. Deepan competition and Mr. I. Ram, London additional senior government advocate representing the state who pressed for any granted, how much time? 4 weeks, 6 weeks time, 4 weeks to file counter affidavit, listed up to 4 weeks.
Under item number 2, I pray for some time to file a affidavit in reply to the counter affidavit by the minor.
Any objection? No.
3 and 4.
How much time?
3 weeks, ma'am.
Mr. Deepan, counsel for the petitioner press for any granted 3 weeks time to file rejoinder to the counter affidavit. Filed by respondent number
3 and 4.
3 and 4. Listed after 3 weeks.
Obliged.
My appraisal. My lord, this is the case, my lord. While the advertisement was, my lord, made for the, my lord, sports quota in the post of assistant mineral development officer in the Department of Geology in the mining.
Affidavit filed.
Yes, my lord.
You
Affidavit
don't-
has been
you-
filed by the company.
You don't intend to file rejoinder?
My lord, after going through the, my lord, affidavit, it is reflected that the government is, my lord, considering my representation, since I have already filed a representation, ventilating my grievances before the concerned authority, and in the affidavit, government stated that they are, my lord, going on, my lord, looking to consider my case, my lord.
Hmm.
And it is yet to be confirmed from the department whether this, my representation has been considered only. So my case was simply that I belong from the kickboxing
No.
discipline, my lord.
What do you want now? You don't, what is going on there?
My
You
lord.
tell what is to be done today.
My lord,
You want to withdraw the case since the petitioner,
no,
since
no,
the
no,
government
my-
is considering your case.
my lord, that I need to cancel, I need to, my lord, ascertain from the
On the
department.
prayer of Mr. C. Model Council for the petitioner listed after 6 weeks.
My lord, let it be 4 weeks, man,
Okay, 4
Wait.
weeks.
because the government is yet to confirm only.
All right, 4 weeks.
Problem.
May I? In item number 4, today I have filed my affidavit in reply to the affidavit in opposition filed by respondent number 4 and 5.
Hmm.
So, this matter may be listed after a week, for admission hearing.
Why week? If it is to be done after a week, we'll do it today.
Today I filed my affidavit in reply.
Okay, after 2 weeks, on the prayer of Mr. J. Jini, sorry, B. Picha, on the council for the petition, is both the writ petition.
Yes.
I'll list it after 2 weeks.
Lordship, here respondent number 6, 7, and 8, and 9, they are yet to file their affidavits.
Nobody is there. Who appears for respondent? 6, oh, is that
Yes.
1 to 5 have filed affidavit?
Yes, up to 5 they have filed.
Yes, Mr. Tapia.
Finance and Administrative Reform Department.
I will give him some time.
Not Mr. B or on council for the petitioner, petitioners
Yes, sir.
and Mr. S. Tapin Lal is senior government advocate representing all the respondents who press for another grant for the 4 weeks time to file counter affidavits by the respondent 6 to 9.
Yes.
Listed up to 4 weeks.
May I please, Lordship?
Yes,
Lordship, Standing Council Tijamo, Standing Council for Education Tijamo, he's out of station, Lordship. So,
okay.
Lordship, matter may be listed on Monday, Lordship.
Any urgency? No matter?
This is transfer matter.
Okay. No stay.
No, stay. Therefore, last time also, this honorable court was inclined, but then they had taken repeatedly time after time.
He is again praying for Monday. Was it still Monday?
Lordship, 18, Lordship.
18. 18 is Monday.
Fine.
You are
I am appearing correspondent.
Right.
Respondent note 4
4.
on behalf of T. Garamal,
Okay, all right.
Rajagram.
All right, on the prayer of Mr. K. Tava, Runner Council on behalf of Mr. T. Jamal, Runner Standing Council for the Education Department, listed on 18.
Problem.
Highly blessed.
Mayor Lordship,
Yes,
Your Lordship, this petition is filed under section 11, clause 6 of the Arbitration and Conciliation Act for the appointment of the arbitrator, Your Lordship.
Hmm.
Your Lordship, since from filing this petition, Your Lordship, the counsel of the respondent has deliberately absent in this matter, Your Lordship. And Your Lordship may kindly see the order dated 12/06/23,
12,
12/06/23.
yes,
Whereas the counsel of the respondent has submitted that they want to withdraw their wakalatnama, Your Lordship, from this matter. So therefore, this honorable court has passed an order where it is clearly stated that in the eve of non-representations of the respondent on the next date, the court will proceed. The court will proceed to dispose of the matter
okay,
without hearing the respondent, Your Lordship.
yes,
Therefore, my humble submission before this honorable court to kindly appoint the arbitrator, Your Lordship, since this matter is just pending for appointment of arbitrator, Your Lordship.
Where is the agreement?
Agreement is in page number 19, Your Lordship.
Where is the arbitration clause?
Arbitration clause is in page number 22, your lordship,
20,
22, your lordship,
23,
22, your lordship.
22.
Yes, lordship.
Where is the notice for appointment of an arbitrator?
Notice it in page number 33, your lordship,
Page number
33, your lordship.
33.
Yes, lordship. It is under para 10, your lordship, which is in page number 37.
Hmm?
Page number 37, under para 10, we have mentioned the name of the arbitrator, your lordship.
Did the respondent reply to this notice?
Pardon, your lordship.
Did the respondent reply to this notice?
No, your lordship.
Have they filed affidavit?
No, your lordship.
Respondent has not filed affidavit.
No, lordship. No, lordship.
Affidavit name. Yes, I got panel of arbitrators. This बना के होता है और नोटिफिकेशन ऑफिस में कोई हो उसको पता चल जाएगा हाँ पूछता इसको Under which section the court can appoint arbitrator?
Pardon, Your Lordship.
Under which section the court can appoint arbitrator?
Under section 11 of clause 6, Your Lordship.
11.
Your Lordship, section 11 of clause 3A. Under this-
Close 3.
Yes, Lordship, clause 3A. And then here, the Supreme Court and the High Court shall have the power to appoint the arbitrator, Your Lordship.
What is the dispute?
Dispute is, your lordship, the respondent has taken a loan from the petitioner, your lordship,
How much?
2 lakh, your lordship,
2 lakhs.
your lordship. And on 21 March, he promised that if he failed to return the money, then he will pay the 10 lakh as a compensation, your lordship. And with the interest of
When
10%.
when was the loan taken?
Loan was taken in 2017, your lordship.
2017.
Yes, lordship. An agreement was executed on 29th
November
November.
2020.
Yes, lordship.
Okay. Now. Respondent had appeared along with, respondent had engaged on counsel.
Yes, lordship.
Now, counsel has withdrawn, is not it?
Yes, lordship. Therefore, my humble submission is, your lordship may kindly appoint the arbitrator so that
Who should be the arbitrator here?
we have nominate the name advocate Titi Tarasare, your lordship. And let the arbitrator decide, your lordship.
If an arbitrator is appointed,
Yes, lordship.
how will the arbitrator secure the presence of the respondent before him? Because you are here, you will go to the arbitrator, but this respondent will not go.
Yes, lordship.
So in that event, how will the,
We will send the legal notice, if the court is passed the order, your lordship, we will send all this order to the respondent, your
Okay.
lordship.
all right. Any procedure is prescribed before, under the Arbitration Act? Okay, there is one way of, okay, all right. Then despite that, if the respondent does not appear before the arbitrator, you will hand over order of this court
Yes, lordship.
to the respondent. You will also tell the respondent that on that day, on that particular day, the arbitrator has asked both of you to appear,
Yes, lordship.
and on that appointed date, even if the respondent does not appear, then what the arbitrator will do? Because courts can issue summons, warrants, whatever, is not it? There is a procedure
Then legal action may be taken
And
against
the-
the respondent, your lordship.
by the arbitrator.
Yes, lordship.
Under which provision? Because arbitrator must have power to take action.
Yes, lordship.
Where is that? Because this problem will arise.
Yes, lordship.
Because see, the respondent is deliberately not participating in the proceeding. Yes, if she does not participate, we can appoint. And if we appoint particular arbitrator, how the arbitrator will secure the presence of the respondent so that he can arbitrate.
Lordship.
Any idea?
No, lordship, we'll go to it.
Arbitrator may proceed ex parte.
Yes, lordship.
No, arbitrator may pass an ex parte award.
Yes, lordship.
Okay. Determination of rules of procedure. The arbitral tribunals shall not be bound or
Your Lordship, may kindly appoint,
See, huh?
kindly appoint Honorable Justice C.R. Sharma, Your Lordship.
How many respondents?
Respondent, three respondent, Your Lordship.
Three respondents.
Yes, Lordship. Two are guarantor, Your Lordship.
Three of them had borrowed the money.
No, Lordship. Respondent number one borrowed the money and two are the guarantor of the respondent number one, Your Lordship.
Okay, two are the guarantor of.
Yes, Lordship.
See, that is the panel of arbitrators maintained by the High Court. None of them are from Arunachal. All are resident outside the Arunachal. And the amount involved is only 2 lakhs,
Yes, Lordship.
which may go up to 10 lakhs,
Now total amount is 24 lakh, Your Lordship.
24 lakhs.
Yes, Lordship, including the compensation amount and interest, Your Lordship.
And how much the parties have to bear, pay to the arbitrator as a fees?
Arbitrator, Your Lordship, as per the schedule for Your Lordship, 97,500 plus 3%, Your Lordship.
97,000? No,
97,500.
what is the basis of that calculation?
Your Lordship, schedule 4 of the schedule for point number 3, Lordship. Here it's mentioned that the model of the fees, Your Lordship, whereas it's written that 97,500 plus 3% will be the
Okay,
charges,
all
Your
right.
Lordship.
So you choose whom?
Your Lordship, the Honorable Justice C.R. Sharma.
C.R. Sharma.
Yes, Lordship.
He is a resident of Guwahati.
Yes, Lordship.
All right. We'll upon C.R. Sharma then, Justice C.R. Sharma.
Yes, Lordship.
Okay,
Yes, Lordship.
all right. Had Miss
C. Roni.
C. Roni.
Yes.
Had Miss C. Roni, learned counsel for the petitioner. None appears for the respondents. No. When this matter was taken up for consideration on 12/6/2023, this court had passed the following order. Court 12/6/2020 order. In view of the order dated 12/6/2022 passed by this court, this application, this petition is taken now for final disposal. This is an application under section 11 of the Arbitration and Conciliation Act 1996. Praying for an appointment of an arbitrator. You take your seat. I said, in terms of appointment of an arbitrator under sir. In terms of, I said, okay, in appointment of an arbitrator, in terms of agreement dated 29 November 2020. Executed on 30/11/2020 between the respondent number 1 as first party and the petitioner as the second party. Full stop. By the agreement dated 29, you within bracket you say annexer P1 to the arbitration petition, bracket close, para. By the agreement dated 29 November 2020, the respondent number 1 had borrowed a sum of rupees 2 lakh from the petitioner at the rate of 10% interest beginning not beginning, with effect from 21st February 2017. Full stop. The loan amount along with the interest was agreed to be repaid in full by March 2021. Stop. The respondent number 2 and 3 stood as a guarantors stood as a guarantor for the money borrowed by the respondent number 1. Stop. The agreement dated 29 November 2020 inter alia contains an arbitration clause which reads as under clause 6 within inverted comma code that comma in case of any dispute comma an arbitrator shall be chosen and appointed with the consent of both the parties comma who shall settle the dispute as per the provision of this agreement as agreed by both the parties. Inverted comma close. On failure of the respondent to refund the money borrowed along with the interest as agreed upon in the said agreement, the petitioner had sent a legal notice, sent a notice under clause 6 and 7 of the agreement dated 29/11/2020. For appointment of an arbitrator to resolve the dispute between the petitioner and the respondent number 1. Full stop. Legal notice dated नहीं बोलेंगे. Okay. Under legal notice dated 7/3/2023. So 2022. 7/3 at page 33. Full stop. In the said notice, the petitioner had proposed in the said notice, the petitioner had nominated Advocate T.T. Tara, nominated, stop, proposed Advocate T.T. Tara to act as an arbitrator to resolve the dispute between the petitioner and the respondent number one, and the consent of the respondent number was sought for, comma, to appoint Advocate T.T. Tara as as arbitrator. So the respondent number one neither replied to the notice dated 7/3/2022 sent by the petitioner for appointment of an arbitrator, nor the respondent number one has filed an affidavit in the instant arbitration petition, though the respondent number one, though the respondents had engaged a learned counsel to represent them. Who, however, was discontinued as indicated in the order dated 12/6/2023. Comma, quoted herein above. Full stop. Under the opposite circumstances, having regard to see, just a moment, there is one clause also, clause 7, that all disputes so arising shall be subject to eternal and allowing jurisdiction only. You will call the arbitrator here.
Yes, Lordship.
Okay. Having regard to the clause 6 and 7, we'll add this 7 and earlier also, in where 6 was repeated. Having regard to the clause 6 and 7 of the agreement dated 29 November 2020, executed on 30 November 2020 between the respondent number one and the petitioner in exercise of power under section 11, clause 6 of the Arbitration and Conciliation Act 1996. Honorable Mr. C.R. Sarma, former judge of the Guwahati High Court, is hereby appointed as an arbitrator to resolve the dispute between the parties in the instant arbitration petition. So let a copy of this order along with the relevant records be transmitted to Honorable Mr. Justice C.R. Sarma, the former judge of the Guwahati High Court and the appointed arbitrator for doing the needful. Full stop. Arbitration petition stands disposed of in terms above. All right.
Highly organized.
We'll resume after 5 minutes.
merit of the case, my lord, the case was disposed of, directing the consideration of my representation. So the impugn order, method pertaining to the transport order dated 13/7/2023, whereby I have been transferred from my lord Anini to Kamle. I am the my lord assistant district agricultural officer.
Hmm.
Now, this time, my lord, I am coming with the second subsequent impugn order, whereby the impugn order was passed by the authority on 2nd August 2023.
Hmm.
My lord will find the subsequent impugn order in page number 29.
Affidavit has been filed.
My lord, so far affidavit has not been filed, and at the same time, my lord, I have taken a step to the private respondent.
That is also awaited.
That is awaited, my lord.
Who is respondent number 4?
Respondent number 4 is the person, my lord, whom my lord posted in my place.
Okay.
And one thing, my lord, I am still there in the, my lord, there at the
My lord, this is.
If you don't take affidavit, we will have to pass interim order.
In this case, my lord, I am yet to get the extra copy, my lord.
Extra copy?
Yes, my lord.
Yes, why you will not furnish extra copy?
So from my record,
I could not
I have
give it the respondent. my lord.
varnished, my lord.
Huh?
Evident, my lord, I am ready, my lord. So from my record, my lord.
Where is the receipt?
Varnished.
You show the receipt.
Sorry, my lord, the record is not with me, my lord.
Hmm.
However, my lord, what is the fact is that, my lord, though I am serving there, but my lord, I am in CS, my lord, since the,
No, he says that you had argued this point in the last proceeding and the
Exactly, my-
court considered it
thereafter,
and court did not pass an interim order.
my lord, what
So
that,
he is saying that why should this court pass an interim order on the same set of submission?
my lord,
Okay.
I got it, man.
Yes.
But what, my lord, so far still I remember that the court, what the court observation is that let the notice be issued first, issued first. At the same
Notice
time,
was issued,
my lord,
but you have failed to take steps. That's why he has not filed an affidavit.
my lord, I have taken
This,
steps to the
this
private
court,
respondent.
this court could have still passed an interim order because they have failed to respond. But what he is submitting is their failure to file response is on account of you not furnishing extra copy to him,
My lord.
which you have not been able to controvert.
My lord.
Had Mr. C. Mori, learned counsel for the petition, and Mr. L. Palme, learned standing counsel for the power department, who
Wait,
Yes,
my lord, this is yesterday's bail matter, my lord, when CBI was.
okay. Have you received instruction?
My lord. My lord, lordship has already made observations on that aspect that without granting bail, my lord, if the accused person is allowed to get medical treatment at especially referred hospital at Nigrims, my lord. That conditions, my lord, only. And once the, my lord, the treatment is completed, my lord, he should immediately surrender before the, my lord,
How will he go?
by himself, my lord.
Huh?
By himself, my lord.
Okay.
There is no provision, it's just for my lord.
He is not even in your custody. Is not it?
Yes, judicial.
He is in judicial custody. And moreover, as per the medical report,
Where is-
nowhere
just a-
such serious complication has been referred.
Just a moment. Maybe page 38 is
38.
by the jail
This
authority.
is by the jail authorities, my lord.
Kindly see back pain with joint pain, difficulty in walking, and hypertension definitely and other HO accident surgery on such and such hypertension and diabetes. This is the mallet only referred. Mallet the
Reference is for spinal surgery, my lord, at page 39.
and page 39 is of course mallet this is the routine manner mallet if so advised mallet everyone mallet is referred mallet. This is only format which has been filled up by my dinner and the patient.
By the patient.
Yes, it is patients only the referred with.
How can the
But,
patient
but
fill
no,
up?
no such certificate has been given. This is the only format where the such thing has to be filled up, madam. As per the information, madam. There is no special mallet the refer, wherein history of the mallet the case has been given. By history of the treatment is required to be done, mallet. It is not given. This is only just format filled up by the mallet, maybe the patient or the authorities concerned. Madam. There must be a certain history as per the history of treatment, my lord, if whether it is required to be referred or not, that is the only one thing, my lord. Otherwise, my lord, if
Just a moment. Is the Standing Council Health Department is present?
this morning he
No.
was present, my
In fact, my lord, I have told him,
my lord,
No.
actually procedure is
Huh.
the history of treatment has to be given and where the complication is referred. My lord, in that case, only reference is made, my lord.
No, just a moment. Huh. That is,
How-
see, since this is a document annexed by you,
Yes.
is not it? They have also no idea. So at this stage, I think it would be better to have a confirmation by this
Correct.
doctor.
yes, my lord,
Which-
I have the original also.
So once it is confirmed, that can be done in a day.
Yes.
Had this Standing Council for the Health
If I
Department
don't
been there.
pass that order, I will inform.
Okay,
Otherwise, I have the original also.
let us see.
My lord, normally board has to be constituted and normally if since accused person is complaining for such treatment.
My lord, I had an accident in 2021. I have annexed the photographs also with more. I am not a doctor, I cannot say that. They must have,
He is the, just a moment. It appears one Dr. Time
Murthy has, yes,
had examined you.
yes,
The-
orthopedics.
And then Chief Medical Superintendent is different authority.
Yes, ma'am.
He is not
He's not
the
the
Dr.
attending
Time.
doctor.
No, he's not the orthopedic. Referring doctor is Thai Murthy.
Okay.
Under the Standing Council for the Health
This must be a
Department
procedure, the chief medical officer.
is informed, my lord, the Standing Council for the Health Department is, no, not in the premises, my lord.
Okay,
Maybe he is
alright.
left.
I will inform.
He can inform, let's.
And based per the information, my lord, his treatment, my lord, the ailment can be treated within the state also, my lord. These days, everything is, my lord, available in the teams, my lord. That is the, my lord,
This is,
instruction.
sir, I have not even want to reply to it. Why is this submission being made?
That is the
On what
instruction.
basis, who is the instructor? CBI?
That is
How
the
does he know
instruction.
about of the streams?
My lord, Council for the Mediciner cannot dispute on the instructions received from the, my lord,
Just a moment.
CBI.
No, well, how can I not dispute? Is the CBI an expert? on
You
the-
want that
the-
CBI should be instructed this way or that way.
facilitated
No,
streams.
it is not the
What
correct.
type of submission is this can be treated here or not here?
Spine surgery.
Yes.
Then Lordship may give a directions to the medical authorities to whether really the, my lord, the reference can be made or not.
Or Mr. Deep Angla, counsel for the petitioner. And Mr. M. Kato, another standing counsel for the Central Bureau of Investigation. This is an application under section 439 of the Criminal Procedure Code 1973. Seeking bail for the accused. Okay, the applicant is different, no?
Yes,
Okay.
the wife.
For the accused, namely Sri
Talung Joma.
Talung Joma, in connection with CBI case number RC 0172022A0009 under section 120B/406/409/420 of the IPC, read with section 7/8/13(2) of the Prevention of Corruption Act 1988 on medical ground. In support of the bail application, the applicant has enclosed a referral form for treatment outside Arunachal Pradesh. Dated 1/8/2023 by memo number D6 or what? D6/83, no?
Yes, ma'am.
Stroke 2432-33.
Madam.
Issued by the Chief Medical Superintendent, Tomo River Institute of Health and Medical Sciences, Nahalagan. Post of. In the aforesaid referral form for treatment outside Arunachal Pradesh, the petitioner, the accused, Sri Talung Jomang, has been referred to Nigrims
Yes.
for spine surgery.
No, my lord, referred to is spine surgeon, it appears. recommended intervention is, I think, operation. The handwriting is,
Just a moment.
to whom referred, it's spine surgeon, I think,
Okay, spine surgeon.
yes. Slash neurosurgeon
Spine
or
surgeon. Just a moment.
referred to as spine surgeon slash neurosurgeon. slash
Okay, then what is this operation?
That's the
Recommended intervention. It's
A recommended intervention is what?
operation.
operation and operation oblique. It is
Very difficult.
Very difficult.
Doctors handwriting.
Uh,
This has been done by Dr. Taimur.
that is what I am supposed to say. I thought spine surgery. I don't know what.
It's referred to
Yeah,
spine
just-
surgeon. It's
Report to spine surgeon. Has referred to a spine surgeon,
yes.
stroke neurosurgeon,
Yes.
and there is one more stroke
Orthopedic, it's,
orthopedic, NIGRIMS,
yes.
for the recommended intervention of, what shall we write?
My lord.
Huh?
Operation, I think I can make out. The other one, I just can't.
And the other one,
Sorry, my lord, it is not readable. Operation or we can, my lord, there is this. Very difficult to my lord read.
just a moment, you write, right? For recommended intervention of, just a moment, for recommended intervention, you write dash stroke dash, not legible. Huh?
Yes.
You within inverted comma dash stroke dash, not legible. By Dr. Tai Morton,
Yes.
MBBS, comma. Sorry, Dr. Tai Morton, that will do. Dr. Tai Morton.
He
The,
also is a spine surgeon, it seems.
okay, but his designation has not been given.
It says junior specialist streams
Where?
at the bottom, MBBS, MS orthopedics, spine surgeon, bracket fellow, AIMS Delhi, that is, I think, his degree. Junior specialist streams.
Okay, Dr. Tai Morton, we'll say junior specialist streams. Okay, junior specialist streams. So the referral form, the referral form for treatment outside Arunachal is has been issued by the all that has been enclosed at page 39 of the bail application. Full stop. In order, paragraph, in order to take a final decision in the in order to take a final decision in the instant bail application, it is deemed appropriate to seek instruction from Dr. Tai Morton, Junior Specialist Streams, as well as the Chief Medical Superintendent, Streams, Nalaga, as to whether the referral form for treatment outside Arunachal enclosed by the petitioner at page of the accused Talon Joma, enclosed by the petitioner at page 39 of the bail application has been issued by the chief medical superintendent, Trims Nalaga, on the accused Talon Joma having been examined and referred to negligence by Dr. Tai Mota, Junior Specialist, Trims. Full stop. In the instruction to be given by the Chief Medical Officer Trims Naval as well as Dr. Tai Mota, Junior Specialist Trims, it's also be indicated whether the recommended intervention for which the accused Talon Joman has been referred to negligence can be performed at Trims or not as well. Is not it?
Yes.
Poster. For the yes, to receive the necessary instruction as above. We request
Standing.
Mr. T.
Tita.
Tagum, the standing counsel for the health department. I started with to receive the instruction as above. We request Mr. T. Tagum, standing counsel for the health department, to do the needful, who shall be informed by Mr. Panging, counsel for the petitioner, as well as Mr. Kato, learned standing counsel for the CBI, along with a copy of the order, along with a copy of this order, as well as a copy of the bail application.
Right.
Okay. You can obtain the order.
Yes. My lord, may allow me to file this report, my lord. In fact, I did not file it. This finding is on the basis of the MRI report. I did not.
What is that?
MRI report. This investigation recommendation on the basis of this MRI report only, serial number 80, you will find. Inadvertently, I did not file. I filed it before the learned trial court. I forgot to file it. Not forgot, but I missed.
Oh, then when shall we post this matter?
Next Tuesday.
Okay. List it on 19th. 19th. If you want to file, you can file.
Man.
We'll not mention.
My,
Okay, this is the 19th.
all right.
Yeah, my lord.
Hmm.
My lord, actually,
Oh, my lord, another friend said it is conservative. The other one.
Conservative.
Conservative. That is in case where my lord surgery may not be required. Surgery. Operation slash conservative. Conservative. Yes. Yes. Conservative. Yes. Conservative, yes. That is in cases where surgery may not be required. Yes. Yes. Yes.
Yes, it is illegible, my lord.
I'm just pointing out, though, checked out. Yes. Yes, my lord, they didn't remain like that, yes. Yes. Yes, yes, yes. Oh, yes. Yes.
My lord, actually, in item number 25, my lord, one of my associates appeared and he's failed to mention about continuation of the interim, my lord. My lord, I was actually. My lord, actually, I was on the way, actually, my lord. Yes, my lord. Yes, my lord.
My lord, I'm sorry, my lord.
My lord.
My lord,
Obliged, my lord.
unlisted for withdrawal, my lord. Yes, ma'am. Only thing is that, my lord, the petitioner are pursuing with the government, my lord. At this stage, my lord, they wanted to withdraw. In the meantime, my lord, if it is not considered by the state government, my lord, for creation of the force, my lord. So, dear Commander, at this stage, my lord, I may be allowed to withdraw with a liberty to file a fresh, fresh, if so advised, my lord. My lord. Now, my lord, what happened in this way? Yes, my lord.
You're on from item number 30 and 35.
No, he is not in the list.
35 and
Unlisted
30.
matter. My lord. Only 2-3 matters, my lord. My lord. Yes, my lord. Yes, sir. For the all respondent. Madam. It's advisement. Madam. Now petitioner. No, my lord, there is none. Deeply obliged, madam. No, my lord, I is disposed of, madam. Deeply obliged.
Sir, for item number 30 and 35, your lordship. 30 and 35. Yes. Your lordship, as per instruction, my senior said that he had a telephonic conversation with 30 and 35. First for item 30, your lordship. Your lordship, the SC Standing Council for Education was supposed to mention and take adjournment for item number 30, but since he is not here, so I am mentioning here for adjournment.
Lordship. Yes, Lordship. Actually, we was about to mention this morning, Lordship. We was struck in traffic, Lordship. Lordship may be listed on Monday, Lordship.
I
Lordship,
think it's about reimbursement of pay, your lordship. E-paying. E. P-pertain, yes, your lordship.
Tabang, Lordship. Lordship.
Okay.
Deeply obliged.
And item number 35, your lordship. Your lordship, we received the copy of affidavit yesterday itself. So time may be given to us, your lordship. 3 weeks, your lordship. Much obliged, your lordship. May I, Your Lordship? Lordship, I beg 2728. The petitioner is, petitioner for the council for the petitioner is out of station, Your Lordship. Okay, time. Yes, sir. Yes. Sir. Yes. Yes, Your Lordship. Two weeks.